Mr. President, members of the Court, there is an urgent need for further or modified explicit and specific provisional measures to protect the Palestinians in Gaza from the irreparable prejudice caused by Israel's continuing violations of the Genocide Convention and of this Court's orders, including an express order for the immediate cessation of Israel's military operations in Rafah and across the whole of the Gaza Strip. The change in circumstances and new facts demand it. The extreme risk of irreparable prejudice require it. Israel's approach to the Court's previous orders renders it imperatively urgent. The Court has the power to do it, and our shared humanity compels it. Turning to each of those 5 propositions in turn, first, the change in the situation amounting to new facts demands the indication of further or modified explicit and specific provisional measures. When South Africa appeared before you on the 11th of January, urgently requesting then an order for the cessation of Israel's military operations, humanitarians were already out of words to describe the situation in Gaza. Today they say there are, quote, no words left that can do any justice to the people of Gaza. Tens of thousands of Palestinians have since been killed or injured, including 1 child killed or wounded every 10 minutes since Israel's military operations began, including an almost incomprehensible number of child amputees. Since March in particular, hundreds and thousands of Palestinians, particularly the young, elderly and vulnerable, are dying or at risk of dying of communicable diseases and infections that are running rife due to the rising temperatures in ever more crowded living conditions amidst mountains of waste, fly and mosquito infestations, and raw sewage flowing in the bombed-out streets. Since the Court's last order, entire hospitals, places of learning and healing, including Al-Shifa Hospital, older than the State of Israel itself, have been destroyed and turned into sites of horror and mass death. Gaza's devoted and steadfast doctors and medics have been killed and buried in mass graves, alongside the patients they risked and ultimately gave their lives to care for. The same fate now awaits Rafah's remaining hospitals, doctors and medics. Israel's attack on Rafah, its attempt to control all of Gaza's borders, followed by attacks on the north and the middle areas in recent days, which are of unprecedented violence, even amid the horrors of the past 7 months, herald a turning point beyond which there is no going back, which is reflected in what UNRWA calls, and I quote, a new level of desperation in Gaza. As this Court has heard, this is in effect the end game for Gaza and for its Palestinian people, unfolding under the world's watch. This may well be the last chance for the Court to act to ensure their survival. Second, the extreme risks of irreparable prejudice demand the indication of further or modified explicit and specific provisional measures. The situation in Gaza could not be more urgent, as reflected in the increase in Palestinian fatalities and injuries since the Court's last order and the spreading famine and disease. Acts susceptible of causing irreparable prejudice can plainly occur at any moment before the Court makes a final decision on this case, demanding the indication of further or modified explicit, specific provisional measures to protect the rights found by this Court to be plausible. In Rafah, in particular, in addition to the widespread risk of violent death and injury facing the terrified population of displaced Palestinians, as the Court has heard, dialysis patients and premature babies face immediate risk of death. Some 1.2 million Palestinians will be deprived of access to healthcare if its hospitals are rendered inoperable. The level of destruction that Israel has caused across Gaza and is now wreaking on Rafah threatens the very survival of future Palestinian generations in Gaza. Recent evidence from a former Israeli reservist active in Gaza indicates that soldiers on the ground treat Israeli-ordered evacuation areas, such as those recently ordered for significant parts of Rafah and northern Gaza, as extermination zones, wherein orders to shoot and kill Palestinians are made on the basis of their location alone. This in itself demonstrates the extreme risk to the right of the Palestinians in Gaza not to be subjected to acts of genocide, as does the decision by Israel to deploy 2,000-pound so-called dumb bombs in ever more densely populated areas in the stated, quote, interests of saving more expensive armaments. The routine, repeated authorization of the killing in one strike of hundreds of Palestinian civilians, men, women, children, babies, the elderly and infirm, in order to kill a single individual believed to be a senior Hamas commander, is yet further evidence of that risk. So too are the repeated and routine authorizations for tens of Palestinians to be killed when Israel is bombing so-called low-level targets, so apparently low level as to be nicknamed garbage targets. It is also now clear that Israel is heavily relying on artificial intelligence in identifying which Palestinians in Gaza are to live and to die. One such system appears to function as a form of target machine, generating so-called kill lists of Palestinians selected for execution on bases as tenuous as being in a WhatsApp group with another identified target. Another is the chillingly named Where's Daddy surveillance and tracking system, specifically intended to target those marked for execution when they're at home with their families. The mounting evidence is that Israel's very interpretation of its rules of engagement and of the application of fundamental concepts of international humanitarian law, including distinction, proportionality, necessity, and the very concepts of safe zones and warnings, is in fact itself genocidal, placing Palestinians at particular extreme risk. Third, Israel's contempt and willful disregard of the court's orders highlight the urgent need for further or modified provisional measures in the most explicit terms. In refusing Israel's request to reject South Africa's claim, and in indicating 9 provisional measures against Israel, the court found that Israel's conduct in Gaza gave rise to a real and imminent risk that irreparable prejudice would be caused to the rights of the Palestinians in Gaza to be protected from violations of the Genocide Convention, a risk which is now even more acute. The court's orders created international legal obligations binding on Israel to change its conduct in Gaza. The court made clear in February that those obligations require Israel, quote, to ensure the safety and security of the Palestinians in the Gaza Strip, end quote. Israel manifestly cannot ensure the safety and security of the Palestinian population in Gaza while besieging, bombing, starving, torturing, and executing them. In its March order, the court took note of United Nations assessments that the catastrophic humanitarian situation can only be addressed if the military operations in the Gaza Strip are suspended. Yet Israel has ratcheted up its genocidal military campaign, entering Rafah, the last refuge for so many displaced Palestinians in Gaza. Israel has in parallel reportedly justified its continuing military operations on the asserted basis that, quote, there is no order forbidding us from doing something we're doing today, and the fighting will continue as usual. Indeed, Israel has gone so far as to claim that the court orders are a significant success on the grounds that the court, I quote, rejected South Africa's central request to stop the fighting in Gaza. The court's reluctance to date to order directly and explicitly that Israel cease its military operations in Gaza in order to give effect to the provisional measures indicated by the court, relying instead on necessary implication, has cynically been used by Israel as cover for its conduct. Israel continues to kill and harm Palestinians in Gaza in violation of the court's orders, while its soldiers and political leaders alike continue to publicly express clear genocidal intent towards them. It is self-evident that the provisional measures indicated in the court's previous orders, quote, do not fully address the consequences arising from the changes in the situation that now pertain. The severity of the situation involving horrific human suffering mandates that the court make explicit that which was implicit in its previous orders, and that it now order Israel to cease its military operations in unequivocal, express terms. Nothing else will suffice. In its March order, in light of what the court found to be, quote, the worsening conditions of life faced by Palestinians in Gaza, the court placed a heightened obligation on Israel, not only to enable the provision of humanitarian assistance, but to ensure it. In light of Israel's abject failure to even meet the lower threshold of enabling aid and the ever-worsening conditions of life faced by Palestinians in Gaza following Israel's seizure of the Rafah crossing, the court must at least modify its provisional measures in order to leave no doubt as to what is required of Israel and to give full effect to its previous provisional measures. As the World Food Programme has made clear, I quote, the United Nations and its partners have the means to scale up to all 2.2 million people in Gaza, but only if a humanitarian ceasefire happens. Further, given Israel's manifest failure to ensure the preservation of evidence in Gaza, the recent repeated grim discoveries of mass graves and what the United Nations has called, quote, the prevailing climate of impunity in Israel, Israel must be ordered to immediately take all effective measures to ensure the access of persons able to investigate ongoing atrocities. The measure is critical not just to preserving the rights of Palestinians in South Africa in these proceedings, or indeed to the court's ability to exercise its own judicial functions appropriately. Rather, as a spokesperson for the United Nations Office of the High Commissioner for Human Rights recently stated, these violations should not get forgotten about. They need to be recorded, they need to be reported widely by the media, they need to result in pressure from member states that do have leverage over the parties to the conflict to bring such violations to an end. They need to be recorded so that investigations do take place, and ultimately there is accountability and the cycle of impunity does not continue over and over and over again. Fourth, the court has the power to modify or make an explicit order for Israel to cease its military operations in Rafah and in Gaza more broadly, and to withdraw from the Gaza Strip. The court is empowered and indeed compelled, given the prevailing catastrophic situation in Gaza, to order an express end to Israel's military activities. That is the only measure now capable of preventing irreparable prejudice to the fundamental rights in issue and of ensuring compliance with the court's orders. The fact that such an order would be directed at Israel alone is no bar to the court ordering it. That is for at least three reasons. One, Article 41 of the court statute empowers the court to indicate any provisional measures that, quote, ought to be taken to preserve the respective rights of either party if it considers that the circumstances so require. Article 41 does not require reciprocity. There is no need for an order to be made against both parties. Two, the Genocide Convention itself is no bar to a one-sided cessation order. On the contrary, the absolute prohibition on genocide applies in both non-international armed conflicts, as indeed the terrible examples Rwanda and Darfur make clear, just as in international armed conflict between two states. It applies where only one belligerent is a party to the Genocide Convention, just as it applies where all of them are. It applies regardless of any claims of self-defense, which can never constitute a justification for genocide. And indeed, it applies in peace just as much as in war. And that is because the prohibition on genocide is focused on the absolute inalienable rights of groups, of peoples to be protected from genocide, no matter the underlying circumstances or putative justifications. It makes no sense whatsoever to suggest that the court could not order a state party to the Genocide Convention to suspend its military operations against a non-state actor in order to prevent genocide, unless the non-state actor was itself disarmed. Indeed, it would be contrary to the very objectives of the Genocide Convention, which the court described over 70 years ago as having been adopted for a purely humanitarian and civilizing purpose. It would similarly be nonsensical if, in a claim under the Genocide Convention, the court could order one party to cease its military operations when that party was not even alleged to be committing genocide, as in Ukraine and Russia, but could not hear when the court has itself determined a real and imminent risk to the right of a national, racial or ethnical group not to be subjected to acts of genocide. The evidence before the court indicates that the extent of the carnage in Gaza is of a much greater magnitude than that pertained in Ukraine and Russia. Indeed, the carnage in Gaza is of an order which exceeds by far the necessities of war and the limits imposed by the laws of war. As stated by the United Nations High Commissioner for Human Rights, what Israel is doing is, quote, beyond warfare. Not only is the court empowered to call for it to end, it is duty-bound to do so. Third, the fact that the United Nations Security Council could itself order a cessation of hostilities in Gaza is no bar to the court's exercise of its own powers in this regard. Notably, the distinct and vital role the court was intended to play in preventing genocide was pointedly foreshadowed by the United Nations delegation to the negotiations leading to the very creation of the Genocide Convention. The United States delegate commented that if cases of genocide were brought before the Security Council, the whole question of the veto would be involved. States might try to avoid submitting their disputes to the International Court of Justice, where they would be settled on purely legal grounds, and might instead submit them to the Security Council, where they would be settled on political grounds. In circumstances such as this, where the veto power has been wielded to such devastating effect against the Palestinian people, the indispensable role of a court in ensuring the universal application of the Genocide Convention, its prohibitions and its protections to all peoples equally, cannot be overstated. As noted by the court in indicating provisional measures in March, the Security Council's then operative ceasefire resolution, quote, demanded an immediate ceasefire for the month of Ramadan, respected by all parties, leading to a lasting, sustainable ceasefire. As underscored by the President of the Court, the March provisional measures could, I quote, only take full effect, end quote, if the ceasefire was respected. No such resolution is in place. The court must itself, therefore, create the circumstances necessary for its provisional measures to take full effect. It must order Israel to cease its military operations. Fifth and finally, our shared humanity compels the indication of further or modified explicit provisional measures. As recently stated by the United Nations Assistant Secretary General for Humanitarian Affairs, quote, the war in Gaza has entered yet another horrifying phase. Gaza is now a hellscape for millions trapped under incessant bombardment, where those who have escaped death and injury now risk losing their lives because of a lack of food, safe water, medicine and healthcare. Gaza has, in her words, become a moral stain on the conscience of our collective humanity. I conclude with a slide. It reports an account of a doctor's recent experience in a hospital in Gaza following his departure from the strip. He says this, describing one of the patients there. There was the man in his 50s, forgotten in a room, having had both legs amputated. He had lost his kids, his grandkids, his home, and he's alone in the corner of this dark hospital, maggots going out of his wounds, and he was screaming, "The worms are eating me alive, please help me." That was just one out of I don't know. I just stopped counting because those are the people I think of because they're still there. That sums up what Gaza is today. It's people severely wounded, with life-altering, disabling injuries, bereaved of their entire families, homeless, alone, trapped, without electricity or even basic health care. 7 months later, after 2 orders from this court, they are still there, enduring this horror. They are crying out for help. An order for an immediate cessation of Israel's military operations in Gaza is now their only hope. Enough is enough. South Africa cannot but reiterate its respectful and humble call on this court to do what is in its power to do, what the drafters of the Genocide Convention called on it to do, what our shared humanity compels it to do, to listen to that desperate cry for help from Gaza, and to order Israel to withdraw from Gaza and to cease fire. Monsieur le Président, Mesdames et Messieurs les juges, je vous remercie de votre bienveillante attention et je vous invite à demander à l'agente de l'Afrique du Sud de prendre le podium pour lire ces requêtes.
I thank Ms. Ghralaigh for her statement. I now